Okay, it's time to kick off our lunchtime CLE presentation, and it will be presented by Major Tanisha T. Bramwell-Boose, or as we call her, T2B2. Major Bramwell-Boose is an assistant professor at the Department of Law, United States Air Force Academy. She received a direct commission as an Air Force judge advocate in 2017. Prior to her current assignment, Major Bramwell-Boose served as an area defense counsel, chief of military justice, Chief of Adverse Actions, and Special Assistant U.S. Attorney. She is admitted to practice in the state of New York, and she is also well known as the hardest working member of the DFL faculty. Over to you, Major Bramwell-Boose. Oh, don't want to take your notes away.
Well, thank you. Thank you very much for that introduction, and thank you all for being here. It's ethics, and it's a CLE on ethics, so I understand. I move around a lot, and have to remember to just stay put. So this is your continuing legal education on ethics. I'm trying to make this very interactive, but I can't move around. So if I could get some participation along the way, that will make this less boring and less dry like the typical ethics CLE. As you can see, we have a very interesting, topical, relevant subject that we're looking at, which is the ethical and technical challenges of ChatGPT. So let's start off by talking about, well, these are the things that we're going to be reviewing, but let's start out by talking about what we know about ChatGPT. First and foremost, is there anyone in here who uses ChatGPT? I do. Anyone? Okay. I use ChatGPT. I consider myself an amateur user. I've been using it for about 10 months now. What are some of the things that we know about ChatGPT? Well, first and foremost, we know that it is a large language model, right? And that it generates responses very quickly. It also has the ability to generate human-like text and human-like tone. And as legal professionals, as lawyers, what are some of the things that we use ChatGPT for? Anybody? Just shout it out. Research, yes, to conduct legal research. Anything else that anyone's been using it for? What's that? To create a draft? Yes, you can use that to draft documents. You can use it to draft client communications, emails, memos, client letters, right? And you can also use it to review documents. So it can be used to review like contracts. Anyone familiar with the latest addition to ChatGPT? That's Auto ChatGPT. Anyone use that? No? Auto ChatGPT. So that's the newest addition to ChatGPT. And whereas ChatGPT can review legal documents, Auto ChatGPT can actually draft legal documents. So instead of reviewing a contract with ChatGPT, you can use Auto ChatGPT to review to draft a contract, excuse me, and generate other legal forms. So Auto ChatGPT takes ChatGPT to another level, so to speak. I think we have a baseline of what ChatGPT does, like what it facilitates. And I think we can all agree that it enables us to be a little bit more efficient as attorneys, right? And it can also expand access to legal services. But let's see if we can do a quick quiz and answer some more fundamental questions regarding ChatGPT, like how much do you really know about ChatGPT? So the first question up here is, ChatGPT is connected to the internet. True or false? Who says true? Guess what? You're wrong, unfortunately. So ChatGPT is not connected to the internet, and because of that, it can occasionally produce incorrect answers. So this is taken directly from the OpenAI website, right? So it is not connected to the internet. Second question, ChatGPT has limited knowledge of the world and world events after 2023, 2022, 2021, or 2020. 2021, you are correct. You are correct. Was that a lucky guess? So yeah, ChatGPT can provide, excuse me. I think we skipped ahead. So ChatGPT has limited knowledge of the world and world events after 2021. That's what we're getting from the ChatGPT website, openai.com. And so because it has limited knowledge of the world and world events after 2021, what are the implications? What does that mean? As lawyers, as practitioners, if we're using ChatGPT, we're not gonna get the most current, cutting edge, up-to-date legal research, right? If you are doing more of a historical thing, right, then ChatGPT is gonna be your platform or your research assistant, so to speak, but not for more current events. Question number 3. ChatGPT's chat history can be accessed and reviewed by ChatGPT employees. I think this is an easy one. Yeah, I think we'd all say it's true. And this is how they justify it, right? They said as part of their commitment to safe and responsible AI, they're going to review the conversations to improve their system and to ensure that the content complies with their policies and safety requirements. So what does that mean for us as practitioners, as legal practitioners? We know that or prompts or research history is going to be available to the ChatGPT employees. Question number 4. ChatGPT can provide personal information to third-party vendors and affiliates. What do we think that is? True or false? True, true, it is true. So it says in certain circumstances, we may provide your personal information to third parties without their notice unless required by law. So when your personal information means your name, your email address, maybe your phone number, your physical address, if that was provided, right? Question, I think this is 4 or 5, at least question 5 of 5 probably. ChatGPT can give an answer that's not related to your question. True, so true, okay? It will occasionally make up facts, right? This is from the OpenAI website. It will occasionally make up facts or hallucinate. And by hallucinate, it's gonna talk about fictional things in a manner that sounds very realistic, but it is not. And you won't know. So if you are researching a topic that you know nothing about, and you put in a prompt into ChatGPT and it gives you a response, and you know nothing about the topic, and ChatGPT didn't indicate that it may be inaccurate, you're gonna be going along under the assumption that it is accurate, when it could be information that is totally made up. ChatGPT is hallucinating. So here we see that ChatGPT, it can make us more efficient, right? It can expand access to legal services, but based on the quiz, and I don't know how many of you were surprised by some of the answers, but there are some concerns, right? Privacy concerns, security concerns. And so as lawyers, we know that we are bound by our professional rules of ethics. And some of the rules that are going to be applicable when you are using ChatGPT as a legal practitioner are Rule 1.1, which is competence, Rule 1.6, which is confidentiality of information, along with Rule 5.3, which is responsibilities regarding non-lawyer assistance. So, I mean, it's a CLE, we got to go over the rules, so let's just do it, okay? All right, so let's start off with Rule 1.1. And more specifically, we're looking at comment 8 to Rule 1.1. And it states that to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So this, at first blush, it appears to be very vague, right? What benefits, what specific risks are we talking about? And what's relevant technology? But keep in mind that this is just a model rule. This is the ABA model rule, and states are free to accept it or reject it or even modify it, right? And in the case of Rule 1.1, with regard to comment 8, we have 40 states, that's 40 states, that have accepted this rule, including New York State, and I'm a New York barred attorney. Other states that have adopted comment 8 of Rule 1.1, basically saying that there is a professional duty of technology competence, include Colorado and Florida. And if you want to know what the other states are, I have a list up here in alphabetical order so I can quickly check it for you. But this is an example of New York's rule, right? It says in particular that a lawyer should keep abreast of the benefits and risks associated with technology the lawyer uses to provide services to client or to store or transmit confidential information. So here we're not just talking about a general or generalized risks. This is more specific. This is more concrete, playing into other concerns like security, privacy, and safety. The other rule that we're looking at where ChatGPT is concerned is the Rule 1.6, which is confidentiality. Because if you looked at New York's adoption, or at least modification of comment 8 to Rule 1.1, you'll see that confidentiality is a big area of concern. And under the model Rule 1.6, we do have a duty of confidentiality where information is concerned. And we just talked about the fact that ChatGPT, like what you're entering in your prompt, your searches, the responses, and everything that can be accessible to the ChatGPT employees. The other rule that is applicable is 5.3, responsibilities regarding non-lawyer assistance. Because, I mean, if you are using ChatGPT to conduct legal research, if you're using it to draft documents, you're getting some sort of legal assistance from ChatGPT. And ChatGPT is not a lawyer. Some may say it's not a person either. But in my opinion, the more applicable rule here that we should be looking at is Rule 5.3, which says responsibilities regarding non-lawyer assistance, because you are getting assistance from this artificial intelligence system, ChatGPT, right? And so you have to ensure that at least it is your duty to make reasonable efforts to ensure that the services are provided in a manner that is compatible with your professional obligation. So I don't think it's a stretch saying that Rule 5.3 is very applicable here. I want to move into a little game called Real or Real. I think my accent is really getting in the way here. So let's call it Truth or Fiction, okay? So here's the first one, first story. After successfully representing a child's interest, a law firm sought more than $113,000 in fees, plus interest from the city. However, they were awarded just over $53,000, so that's just about half of what they're asking for, as the judge criticized the firm's use of ChatGPT, writing, treating ChatGPT's conclusions as a useful gauge of the reasonable billing rate for the work of a lawyer with a particular background, carrying out a bespoke assignment for a client in a niche practice area was misbegotten at the jump. Is this a real story or fiction? What do you think? Real? Anyone thinks it's fiction? It's real. This is a case originating from out of New York. The lawyers use ChatGPT to add up their fees, and of course the judge faults their math. That's the headline, which begs the question. I'm not sure if these lawyers were aware of the fact that the ChatGPT's knowledge is really restricted for events and things after 2021. Because if you are asking the city for attorney fees, right? And you're saying this is the going rate, this is the relevant rate, then why rely on ChatGPT to do your math or as some sort of authority on attorneys' fees when this is a platform that is not current up to 2021? So here's another one. A passenger sued an airline after an airline employee bonked him during the flight with a servant cart. After the passenger filed suit, the airline filed papers asking that the case be dismissed because the statute of limitations had expired. The passenger's lawyers object, submitting a 10-page brief that cited more than half a dozen relevant court decisions. However, no one, not the airline's lawyers, not even the judge himself, could find the decision or quotation cited and summarized in the brief. That was because ChatGPT had invented everything. True? Truth or fiction? Yeah, this is a very popular one. Very true. So this is the headline. Here's what happens when your lawyer uses ChatGPT, which not necessarily, right? If your lawyer is doing what he or she's supposed to be doing with still using their analytical skills, still fact checking everything, right? And so that's what happened. What rules are implicated here? What rules did this lawyer violate? We just had 3 of them up there. Comment 8 to Rule 1.1. We had Rule 1, which is the duty of technology competency for Comment 8 to Rule 1.1. We had 1.6 up there, which is confidentiality of information. And we also had 5.3, which was non-lawyer assistance. Any of those possibly violated here? I heard competence, so on 1.1, comment 8, and which other one? 5.3? So give me one moment here. I want to provide a little bit more information, a little bit more context regarding this particular case. So again, this is another case from out of New York, and this attorney had practiced for 3 decades. So not a brand new attorney. And he told the court he had never used ChatGPT, and therefore he was unaware of the possibility that its content could be false. So he wasn't aware of the whole hallucinating that ChatGPT could do to make up stuff. He said he even asked ChatGPT to verify that the cases were real, and ChatGPT said, yes, they are. So yeah, definitely here is a person using ChatGPT who doesn't understand the program very well and doesn't realize the consequences for not fact checking or at least double checking what is provided to him by ChatGPT. I believe you mentioned 5.3 as well. How so? Okay. So let's go back to 5.3 quickly, see if we can see exactly how that applies here. It says if an attorney decides to use done attorneys outside their law firms, they have a duty to make reasonable efforts to ensure that services are provided in a manner that is compatible with his professional obligation. And we all know you don't just cite cases, you're supposed to be shepherdizing, right? And double checking to make sure that they are correct, that they're current. Okay, so here's the other one. Lawyer is facing possible discipline for citing a non-existent case generated by ChatGPT. The lawyer included the non-existent state court decision in an appeal to revive her client's lawsuit, claiming a doctor botched an abortion. The court ordered the lawyer to submit a copy of the cited decision after it was not able to find the case. The lawyer responded that she was unable to furnish a copy of the decision and admitted to including a case that was suggested by ChatGPT, but said there was no bad faith, willfulness, or prejudice towards the opposing party or the judicial system. Real or real, or as I say, my accent is getting in the way, so truth or fiction? True, yep. This one is also true. It is another case originating out of New York, my state. So the Second Circuit of Appeals referred this lawyer to its attorney grievance panel after she used ChatGPT for research in a medical malpractice lawsuit and did not confirm that the case she cited was valid. So again, what rules are we looking at here that were violated? Let me go back to the rules. Which ones do we think were violated here? 1.1, yes. Anything else? Maybe 5.3 as well, because 1.1, especially for New York, says that you should be keeping, as a New York licensed attorney, keep abreast of the benefits and risk associated with the technology that you're using to provide services to clients or to store, transmit confidential information. And her service, this is the representation of this client in an appellate court, right, where she did not double check the law that was provided by ChatGPT. So again, another lawyer here who is not aware of the fact that ChatGPT can hallucinate and really make up things in such a way for them to sound very real, even though they are fictional. Okay. Here's another one. OpenAI was forced to take its popular ChatGPT bot offline for emergency maintenance after a user was able to exploit a bug in the system to recall the titles from other users' chat histories. Users posted screenshots on Reddit that their ChatGPT sidebars featured previous chat histories from other users. Only the title of the conversation, however, not the text itself, were visible. The chat history bug may have also potentially revealed personal data from 1.2% of ChatGPT Plus subscribers. So that's their $20 per month enhanced access package. And it was also possible for some users to see another active user's first and last name, email address, payment address, the last 4 digits of their social security number, and credit card expiration date. Truth or fiction? Does this happen or not? What do you think? Okay, so you think it's true? Okay, so you think it's part true, part 100% true, 100% true. OpenAI said that a bug leaked sensitive ChatGPT user data. And so it was used to share chat history, titles, and email addresses and payment information. I think when this happened, it first was noticed by a Reddit user who posted on that social media platform, which is a public social media platform. And then I guess OpenAI looked into it and then put some sort of a press release out confirming that, yeah, this actually happened. So 100% true, no facts were added, but I'm gonna add some facts just to change up the scenario a little, right? So what if you were an attorney using ChatGPT at this point when all of this happened? Like what would have been first of all, what would have been the implications? Before we even, would you be concerned? Would you be bothered at all? Say you were someone using this for legal research, or maybe you were using it to draft documents. Yes. So it would have been because you'd be the subscriber, you're the attorney. So your personal information would have been leaked. But keep in mind too, like your ChatGPT prompt, like your searches and like the topics and so on and so forth would have been visible to other ChatGPT users? Okay, so concern for your personal information, and you think, yes, there was a leak, but not so bad because your client information, meaning identifying your clients, wouldn't have been leaked. But at least the stuff that you would have been working on for your clients, all that research. What if Yeah, so I was gonna add another fact to that to say, what if you are like a boutique law firm, working on, there's some cases are only worked on or brought to the Supreme Court by certain like really boutique law firms. And just based on your, what you're researching or maybe the depth of the prompt or the research, probably they would have been able to identify it. So if you're an attorney in this particular scenario where that happened, what are some of the rules that we'd be looking at that would have been violated or breached? Let me go back to the rules just to remind us all. So I am so sorry. I am trying to make this interactive and I appreciate, but I couldn't hear to repeat. Thank you, sir. So he's saying that the attorney should have taken that into consideration, that there could be a possible leak, or that even though we know ChatGPT's employees have access, excuse me, to the information. So that should have totally been taken into consideration. And if not, then is it rule 1.1, sir, that you're saying? Or in 1.6. So yeah, absolutely. So I've been very transparent. I do use ChatGPT, and when I'm putting in my ChatGPT prompts, I make sure I scrub them. I make sure that there's no identifying information. Or if you feel the need to have like a subject to whatever sentence you're typing, you could just make up a name. So you just have to be very careful about your ChatGPT prompts when you're putting them in, because I mean, they may never have another leak, but who knows? But even if there is never another ChatGPT leak of this magnitude, we know that their employees can see or search for or chat GPT prompts. Okay, we're a half an hour in, and I was expecting this to be just a little bit more interactive. I do appreciate the folks that are here. I was just expecting a little bit more people and a little bit more of interaction. But takeaways before we get to questions is that yes, definitely ChatGPT can increase your access, can increase access to legal services, and it can, of course, improve or efficiency, but we have to be certain and at least ensure that we're not violating or professional ethics rules. Like I said, 1.1 is implicated, more specifically comment 8 to 1.1. 1.6 is also implicated, and we have Rule 5.3 that is also implicated. Because if you're not doing that, in addition to your clients can just lose confidence, in you as an attorney, if you were a part of that leak and God forbid it got out, and folks knew exactly what you were researching and what you're going to be arguing for particular cases, especially the opposing side. Clients can just totally lose confidence. But more important, you can be sanctioned, right? For the majority of the cases, if not all the case examples that I put up there, and they were all truth, none fictional, none of them was fictional. They all show that, Rule 11 is something that we have to take into consideration because you can be sanctioned. Saying that you are not aware of how ChatGPT operates is just not enough. Especially if you're from a state like New York that has adopted this duty of professional technology competency, right? So you have to make sure that you are being trained up on the technology that you're using, that you know the risks and benefits associated with the technology that you're using, and so that you can use it properly as a legal professional. Yes, sir. So like I said before, I'm somewhat of an amateur ChatGPT user. I have not used it to draft legal documents. I certainly have used it to draft like other smaller documents, like maybe memos and maybe emails, maybe a few letters, but not draft documents. But you bring up a good point. If you're going to be using it, because we know that there's been a leak before, because we know that the employees are, privy to the documents that you are drafting or your legal research in there, you're probably, whatever prompts you're using, you're gonna have to scrub or make sure that you're not putting in any personable identifiable information into your ChatGPT prompts. So I have not used it to draft documents, so I don't even know how that would, legal documents of that magnitude, so I don't even know how that would work. Is there anyone here who wouldn't consider themselves an amateur user? Yes. Yeah, well, thank you there. And I think what we need to recognize is that for some of these scenarios, we don't have clear-cut answers. For some of them, we do. So for example, if ChatGPT is going to be suggesting a case, like even if you had Googled a case or someone told you about your case, What do you know you need to do before you're going to include that case in a brief that you're submitting to the court? You know, you gotta verify, you gotta verify, you gotta shepherdize, right? You have to do that. So in some scenarios, in some cases, you know, we know what it is that we need to do to make ChatGPT more efficient, to make it work. In other scenarios, like if you're using auto chat GPT to draft entire legal documents, I guess that's gonna determine on the prompts that you're putting in, and whether or not you're gonna make up names, use fictional names. And then maybe the reverse too, like if you're using ChatGPT to review a document like a contract, right? You have to be careful. Maybe you're gonna have to scrub it a little before you put it in. But how much do you scrub? What kind of help are you looking for from ChatGPT? Are you gonna have to scrub out the stuff that you really need ChatGPT to help you with? So still a lot of answers, and some of them, still a lot of questions, excuse me, and a lot of them no clear-cut answers. Yes, sir. So that's a good point too, sir, because so what he's suggesting is that you do a more generalized prompt using ChatGPT, and then after you get the product, you finalize it. There are actually people online who make a living from using ChatGPT, and they're very transparent to the folks who are contracting them to do these research or draft these documents, where they actually use ChatGPT in its entirety to do everything. And then they go over it for like the fact check inside of it, the verification, and also to make it sound less like ChatGPT. Like we know that ChatGPT has this ability to generate a human-like text and like have a human-like tone. But I've been told that sometimes you kind of know what, like when you're reading a document, that if it's generated by AI and more specifically ChatGPT. So probably not a bad idea, sir, to have a more generalized prompt. And then you finalize the document yourself. Because as lawyers, do you want to rely on ChatGPT entirely to do everything? Think about the critical thinking skills, the fact that ChatGPT's knowledge is restricted for events and world events after 2021. Like, you know, it's not online, right? So those are things you have to take into consideration when you are using artificial intelligence, and more specifically ChatGPT. Yes, sir. So I've used it for an email once, just testing it. And the email that came out just didn't sound like an email that I would write. It didn't match my tone, you know, and so I had to really go, it sounded very rote, very robotic. So yeah, so I had to still go in and tweak it. But I wouldn't send, I guess I could have sent it out the way it came back, but I'm like, that's not me. They would be like, who sent this email? It just didn't sound like me. That's not the way I speak. That's not the way I write. The syntax is just completely different. And so I had to like tweak it a little. Yes. Yes. Yeah, so I haven't used any of the more advanced or more current models. I haven't even used Auto Chat GPT. I've just been using standard Chat GPT, and it's not even the fancy subscription Chat GPT. It's the free one. So I'm not sure to what extent the newer models would be able to operate compared to basic Chat GPT. But what I do know of, at least about Auto Chat GPT, is whereas regular or basic Chat GPT will review documents, Auto Chat GPT can actually create these documents. It can create motions for you to submit to court. It can create contracts. Whereas basic Chat GPT can just review those documents or help you with the legal research. Auto Chat GPT can also create legal forms. I don't know if that answers your question, but I just don't have that level of familiarity with those other programs. Thank you. Yes. Thank you, sir. I can hear you. I've seen that. Good. Thank you so much for assisting with that question. Yeah, I kept this limited to ChatGPT. I kept this to ChatGPT, limited it to ChatGPT and not AI in general because I am not a techie person, but I was told that this CLE should somehow be linked to technology. And I'm like, well, I use ChatGPT. It's relevant, it's topical, and so that is why we're doing it. But thank you so much for the assist with answering that question, sir. Are there any additional questions? What about the bar rules? That I had up there, Rule 1.1, Comment 8, Rule 5.3, and Rule 1.6. More specifically, this duty, professional duty of technology competence. What do you guys make of it? Do you think this is something fair? Like, is it reasonable? Yes, sir. I think I understand where you're going. I think you're saying that reasonable minds may differ as to whether or not Rule 5.3 is applicable because ChatGPT could be seen just as a research tool, the way we would use Lexis or Westlaw, right? And not necessarily non-lawyer assistance. And I think an argument can be made for that. But if you've looked at the examples, the real life examples that I put up there, it's not really 5.3 that's at issue. It's 1.1. And if you were a lawyer using ChatGPT at the time when they had this huge leak, then 1.6. But I get your question, sir. Yes. I'm sorry, sir. Could you repeat that, please? So he's saying it could be different if you're using ChatGPT for drafting as opposed to just researching cases. Because if you're drafting, then that's more like non-lawyer assistance. So again, also, it could be how you use it, right? So we're lawyers, you know, we can argue, we can, every little point, every little thing, we can see it a different way from another perspective. And this is just a good example of that, yes. Are there any other questions? Yes, sir. There what out there? Understood. So I think it depends on this brief bank. Is it internal? Is, you know, if we think of ourselves as JAGS and the JAG core is your law firm and you're getting the brief bank from your law firm, you know, we have different levels of confidentiality. I get it. But also too, if you were to get a brief from a brief bank, right? Or even a memo, you are going to edit it. You're going to make changes to it. You're going to make sure that the cases are still good law. So you're going to shepherdize. And yeah, you're going to be plugging in like a lot of your own facts to it. So I think that's where it's kind of different with ChatGPT, where if you are using like Auto ChatGPT to draft your motions, then you probably need to have that same level of diligence, like with a finished product, the way you would if you're starting from a draft from a brief bank, right? Like still make sure that you're checking and shepherdizing. But I see what you're saying, sir. I get your point. Yes, sir. Yeah, absolutely. It has the ability to make our lives so much easier for us to be more efficient, for us to probably take on more clients or serve our clients even better. It has the ability to expand access to legal services, but we can't be using it blindly, right? We have to be aware of the cons, the pitfalls, and just making sure that we're still using our critical thinking skills, yes, and we're still doing our due diligence as lawyers, yes. We have just about 9 minutes or 8 minutes left. Any additional questions or thoughts or concerns? You're my savior. Thank you. It is, sir. Yes, it's been adopted by 40 states. And if you go back to one of the New York scenarios that I put up there, the airline case, one of the attorneys that used ChatGPT, he's been practicing for 30 years, right? And he said he, no kidding, had no idea that ChatGPT could make up cases, and that he actually asked ChatGPT if the cases were real. And the response he got from ChatGPT is like, yes, these cases are real. I would say maybe just look up your state bar rules, because just to see if they've modified this, if they've adopted it. 40 states have. I have the New York. I'm New York barred, so I need to know, what New York says on this. And I know that for New York, it's not very general, it's very specific, and it's just what the services that you're providing to client or to store or transmit confidential information. I think it's, and I think it's a reasonable ask. I agree with you that it is a huge change, but I think it's a reasonable ask. And if you look at a state like Florida, they take it a step further, and they're saying, in addition to having this professional duty of technology competence, you also have to have the training. And I don't know how they're tracking that, if like when you are recertifying every 2 years or what, that you have to show that, or at least sign something to say that you have. But yeah, I encourage you all to like just go look up your state bar rule, comment A to 1.1, to see if it's been adopted or to what extent it's been modified, to see what your obligations are. Yes, sir. Yes, it's a cost benefit analysis. Yes, so you just gotta, figure out, is it really worth it? How helpful is it? How efficient, how much more efficient can you be using it? And is it worth, the possible leaks and their employees having access to your information? Yes, sir.
Came to you, had to file something, and you didn't want them as a client, you told them, hey, you go to chat, they can help you. Is that-
Well, I mean, if it's a non-lawyer using it and it's for their case and they know the benefit, I mean, if they submit a brief to the court citing cases that don't exist, I mean, they're still gonna have to answer to the court, right? It's interesting that you should bring up that scenario, sir, because one of the I know all the cases that I put up there are from straight out of New York, but there's one Colorado case that I found in my research, and it's someone who was recently barred, so about a year and a half as an attorney. And he's a personal injury attorney, and someone came to him. This individual, this client came to him after having represented himself. So this is a pro se person who came to this attorney for his competence and expertise. And this attorney went and used ChatGPT, submitted a motion to the court, and again, cases that did not exist. So I'm like, maybe this guy should have just continued on representing himself pro se. Okay, other questions, comments, or concerns? If not, that's it. Thank you so much.